24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.
Hello, welcome to today's exciting edition of Law and You. You know I'm always excited to come to you with this program where we discuss law as it affects you, as it affects me, to enable you to know your legal rights and how to take full advantage of them. Now today is a particularly interesting day. I've got my friend, my learned friend in the studio with us, looking at a very interesting topic on money and justice in Nigeria. A lot of people say that if you have money, you have justice in Nigeria. If you don't have money, you don't get anything in Nigeria. Is that correct? We'll be looking at it today when we come back in just a second.
24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.
Okay, so my friend is Andrew Enwanta. Do I pronounce it properly? Enwanta, barrister and solicitor of the Supreme Court of Nigeria, a social conscience crusader, a lecturer, Faculty of Law, University of Calabar, and human rights activist, ex-this, ex-that. So he's Andrew Enwanta. Welcome to the studios.
Thank you so much, sir, for having me.
Tell us a little bit about justice in Nigeria. Is it correct that oftentimes justice goes to the highest bidder in Nigeria? Or is it that justice is blindfolded? It doesn't see whether you have money, whether you don't have money in Nigeria, whether you are in the corridors of power, whether you are a poor farmer in the village. Does it matter?
Thank you so much, sir, for that very beautiful question. You know, it's one question that resonates, especially when we consider the judiciary, which ought to be the last hope of the common man. Because that aphorism holds true in a system where when somebody goes to court, he believes at the end of the day, it will just be justice and nothing more than justice.
Okay.
But unfortunately, when we look at recent events in our country, not just recent events, we've always had it during the time of the military. We had a system where when you go to court against the military, you could tell the outcome.
You could tell the outcome.
You could tell the outcome. Remember the Lacamins case. After the Supreme Court gave that very beautiful decision, the military came up with Decree 28 of 1970 that abrogated that decision of the Supreme Court. But the beauty of this is that even during the military, we had an era when the likes of Kayode Esho, the likes of Puta were at the apex court. That was between 1985 and 1987. We had many cases that went up to the Supreme Court where the courts, irrespective of who was involved, gave justice. And it was this same period, I remember Oputa said something about justice. He said justice is literally traffic.
Okay.
Justice for the accused,
Yes.
justice for the state, justice for the victim.
Yes.
But unfortunately, we cannot talk of justice today in terms of it being a territory traffic. Unfortunately, when you have money, there's nothing you cannot get in Nigeria. And justice includes one of those mercantile, products that one can, as it were, say, oh, I know the judge. And I think it goes to this issue of the process of appointing judges. So these are issues that I think if viewed holistically, most of what we complain of in the system flows from process and procedure. Until the issue of process and procedure is addressed or nipped in the bud, this issue of saying justice goes to the highest bidder would not be addressed.
Okay, tell us a little bit. You mentioned the Lacamins case. Most of our viewers are not, they are not strictly speaking lawyers, so they may not be familiar with when you say Lacamins case. You want to tell us a little bit about Lacamins case briefly?
Yeah, thank you so much. I think the Lacamins case, the title of that case is E.O. Lacami and another, that's the daughter, Tokelomo, and the Attorney General of Western States.
Okay.
Lacami was a public servant who, of course, served in the then Western States regional governments.
Okay.
I know the Western States, of course, those states that make up the present southwest part of Nigeria.
Okay.
Though it used to be part of the then Western States.
Okay.
But with time, we now became Midwest.
Midwest, okay.
Between 1963 and 1964.
Okay.
By way of a referendum. So after the first military coup d'etat, he was one of those public servants whose assets were seized.
Okay.
I mean, on account of corruption and what have you.
Okay.
So the process by which his assets were confiscated,
Yes.
you know, he challenged that process because there was a decree, there was an edict.
It was a military regime.
A military regime.
Okay.
So the edicts tend to was in conflict
Yes.
with a particular decree.
Okay.
So when he went to court,
Yes.
between the time the High Court gave a decision and court of appeal,
Yes.
Decree 45 came, taking away the court's jurisdiction.
Okay. To entertain
To entertain the
the
matter,
matter.
the
Okay.
matter was already in court.
Okay.
So he now further appealed to the Supreme Court. And the Supreme Court now says that particular piece of legislation was an exercise of judicial powers because we're now trying to restrict the powers of the courts.
Okay.
And unfortunately, I recently made reference to the recent intervention of the National Assembly in Edo.
Okay.
Because when you look at the resolution saying that the House of Assembly, where there's a court order already,
Yes.
can, I mean, try to take away the powers of the courts. Because if the court restrains the police from intervening,
Yes.
the National Assembly now recently gave that counter order,
Oh, yes.
asking the police to take over the house.
Yes.
So when I was making reference, I said the Lakamin's case,
Yes.
the only authority we have in history.
Okay.
Where after the Supreme Court gave a decision,
Yes.
the military now came up with a decision.
Okay. With a decree,
A decree. It was a decision they made.
which seemed to set aside the judgment of the court. Okay.
They came up with that decree
Okay.
because at the Supreme Military Council they decided that the Supreme Court cannot overrule our authority. If we have made a decree taking away the court's jurisdiction, how dare the Supreme Court? I mean, that was where this problem started from. If we have to trace the issue, and when I asked him who was the Attorney General at that time, the Attorney General was still Elias.
But Taslim Elias.
Elias,
Okay.
who 3 years later became the Chief Justice of Nigeria. He was appointed directly from the bar. He didn't go through
Wow.
that customary process of going from the High Court.
Okay. To the Court of Appeals.
And you know, imagine that kind of patronage coming from the military regime of that time. And unfortunately, the process of appointing Chief Justice of Nigeria became political from that time.
Well, but when he was Chief Justice of Federation, was he not celebrated? He did not distinguish himself? Or could it be said that throughout his career he was more of someone who sided with the military? I mean, is that a fair assessment?
I'll be fair if I give you a little of his history.
Okay.
Because this was a man that was Attorney General.
Yes.
Between 1966, he served, or rather, from 1960, he had served the government of Tafawa Balewa
Yes.
as Minister for Justice and Attorney General of the Federation.
Okay.
He served Abu Ironsi as Attorney General. He served Gowan as Attorney General. Up to the time he was now appointed in 1973 as the Chief Justice of, 1972, as the Chief Justice of Nigeria, from being Attorney General of the Federation. And unfortunately, you remember that in 1960,
So
that went to court.
Okay.
You remember Duheti and Balawa's case
Yes.
over the Tribunal and Inquiries Act,
yes.
a bill that was passed the same day it was initiated and
Yes.
published.
Yes.
And who was the Attorney General? He was the Attorney General. And that was the first piece of legislation that would take away the court's jurisdiction as against the clear provisions of the 1960 Constitution. He was the Attorney General at that time. So when you don't give quality advice, and those decisions are political, and in turn, you are now rewarded with the office, I mean the hallowed office
Okay.
of Chief Justice of Nigeria,
Yes.
I mean that leaves much to be desired. Why would the same military who you are advising,
Yes.
wrongly or rightly,
Yes.
not influence you as Chief Justice of Nigeria? Because as it were, we don't practice a parliamentary system where the Lord Chancellor is the head of the judiciary, he's also a member of the executive, and the head of the of Parliament also
Yes,
too as
yes.
the head of the House of Lords. So we almost had that kind of situation in Nigeria. A hierarchy of some sort.
Okay. Now you are talking. I'm not a good fan of history, whether legal or what kind of history. I would always say history is past. Now we are here today. Can you say that in present day Nigeria, with the quality of judges that we have from the magistracy up to the Supreme Court, that any of them by any chance could be likened to Tio Elias?
I think that golden era is gone. I give you the closest it stands.
Yes.
When the CGN went before the Senate and it was asked a simple question, technicality.
Yes, I remember about Senator Abaribe asked him about the technical justice over substantial justice. What is the philosophy of the Supreme Court? What does it see as the philosophy of the Supreme Court going forward under his leadership?
Under his leadership,
And-
he
and
gave a
he-
background.
Yeah.
I mean, the CGN had that opportunity to explain what technicality was.
Yeah.
But he was talking of technicality in terms of one's technical ability to fly. He even used the expression, drive a plane, flight. I mean, this is the Chief Justice of Nigeria, because he went there as an acting Chief Justice of Nigeria.
Yeah.
So when the head has such, I mean, I don't want to use the word incompetence, but limited ability in distilling issues that border on professionalism, there's a way it cascades down. Because it gives this impression that Nigeria is a system where tokenism is the order of the day. Because for me, I don't subscribe to the school of thought that there must be a senior. We should sacrifice seniority for merit. Because if we don't do that, a day will come when anything will go in our profession. If a man is corrupt, will you now, because of seniority, allow him to be the head of an organ as important as the judiciary?
Okay, let me just ask a question. Was it Shakespeare? Shakespeare said, to err is human. I think it was Shakespeare, but to forgive is divine. He said the quality of justice is never stained, something like that. The quality of mercy is never stained. It is like the gentle rain that droppeth from heaven. It's twice blessed. It blesses him that gives and blesses him that receives. In other words, mercy and justice congregates at a point when we realize that every human being can make a mistake and make an error. Don't you think when the CJN, Chief Justice of Nigeria, was asked, about technicalities, and he seemed to have related it to somebody who has a technical knowledge of an area of science and all that, that he may just have made a mistake, which probably anybody who is under the glare of the whole world on television could have made?
Yeah, thank you, sir. But, I haven't gone through the bill. We started off as a magistrate, went to be a Qadi of the Sharia Court of Appeal, went to the Court of Appeal, was there for a couple of years.
Yes.
He served in the Supreme Court in different capacities as the Supreme Court judge, as the Deputy Chairman of the National Judicial Council under when he was chairman, and acted in that capacity for at least a couple of months. One respect, and this technicality is something that is simple. Because when you talk of technicality, when there's a lacuna in the law, right? Judgment can go anywhere. And we now talk of substantial justice.
That's a good technical justice. Somebody
that
taking advantage of
is enough. You don't need to talk of the technical experience of flying the plane. I mean, that was not necessary. I mean, he traveled too far. And we say lawyers do it in briefs. We do it in briefs in terms of we are brief and we do matters. So you have a brief.
Okay, but I would say that would you say that is an offshoot of corruption or offshoot of monetization of justice? I mean, like you said, he has served as a magistrate, became a Grand Qadi, became a Justice of Court of Appeal, and then rose to the Supreme Court, where he has served for years. So that is a man, I believe, his lordship would have paid his dues over the years. I've appeared before him at the Supreme Court in Nigeria, in Abuja, and he didn't come across as someone who didn't quite appreciate. I mean, you read some of his judgments too; they are quite lucid. So I don't know. I think that I like to hear what you have to say about it being a situation where the Chief Justice of Nigeria is not a pace setter. It's just a judge in his own right who performs administrative functions. So that his performance or his conduct, his attitude cannot necessarily reverberate, percolate down the line. Is that a fair comment?
I think it is, because when you look at our profession, when we say we are learned, it goes with 2 or 3 things, namely our ability to communicate. The question is, the average Nigerian, was the average Nigerian convinced with that answer?
But it was subsequently confirmed by Senate.
It explains our system of tokenism where we just tell people to come and take a bow. I've never seen a situation where the Senate will send back a nominee apart from Mago's case, which of course some persons will argue was politically
Motivated.
The rejection was politically motivated. He had a running battle. Some of these persons were under his radar and all of that. So for me, I think we should spend more time on merit in this country. And that's where this issue of process and procedure comes in. We should now think, because it is not a Nigerian problem, it's a legal profession problem. I think the stakeholders of our profession have to have a round table. We need to rejig the system in such a way, because when you look at the 1999 constitution, the composition of the NJC gives so much power to the Chief Justice of Nigeria, in a way that he appoints more than 50% of the members of that body. So how can that body bring it to book? So this brings into focus the way Amana Onohe was removed. Because of course the presidency knew one thing, that there was no way Onohe we allowed them to do a proper investigation. And even when his argument was that NJC should investigate, he cannot be a judge of this. It goes against the twin pillars of natural justice. Audi Aturam Patem, Nemo Jesus King Kasosua.
Okay, all right, you are going to continue, but so that our viewers will follow us, use the abbreviation NJC. It's important to clarify.
That's
the National Judicial Council, and that's the body that is responsible for the appointment of judges, discipline of judges, and
recommendation
for removal of judges. So that's the NJC. Then you also use two expressions: twin pillars of justice, Audi Otirem Patem, and Nemo Judex in Kausasua. So what's Audi Otirem Patem?
It talks about here the other side, right?
Okay, Audi Otirem Patem here the other side.
Nemo Judex in Kausasua.
Yeah.
You cannot be a judge in your case. The moment you have an interest in a particular case,
yes,
like in the case of Onohe,
yes,
he was Chief Justice of Nigeria,
yes,
petitions against him,
yes,
and he wanted to sit over that same petition as chairman of the National Judicial Council, but now saying that it's the NJC that has jurisdiction.
To discipline him.
Of course, you step aside. Stepping aside means that you leave the office of Chief Justice of Nigeria, which makes you the head of the judiciary, and allow a proper proof. If at the end of the day, it turns out that, oh, those were just mere allegations, you return to your office. Because you cannot sit there, because your power is such that the people who are there, you appointed them, or you superintend over their affairs, looking at you, they are looking at the law. You cannot go against the law. You become a law unto yourself. So that was the mistake I think he did. But unfortunately, he had the opportunity to fuel the air, he now had to resign.
Okay, we're going to come back after a short break. I'm talking with Barrister Andrew Enwata, Stormy Petrel of the Nigerian Bar. Don't go away, we'll be right back.
24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.
Welcome back. It's hot in here, talking about money, the role money plays in justice in Nigeria. I'm talking with my friend, my learned friend, as we address ourselves. Every other person is educated, but lawyers are learned. Looking at money and justice in Nigeria. Now, you mentioned the unorganized case just before we went on the break. Do you think that was an issue of corruption or monetization? Because at the end of the day, nothing happened to him. He resigned. His resignation was accepted by the president. Everybody was happy. Till date, there's been no prosecution for corruption. There's been no assets confiscated. So, don't you think that it was just a politically motivated?
There is this thinking some of us have.
Yes.
That if you look at the country called Nigeria, it has 4 organs of government.
4
Beyond
organs.
the traditional theory we know, corruption is the 4th organ of government. We think so because we feel it runs through the 3 other organs.
Okay.
And I say this for very obvious reasons. If the federal government has very strong allegations that, of course, even Onohe confirmed by himself, because he said, oh, he flew to declare some of those accounts, the figures that, I mean, very mind-blowing figures. How do you use such amount of money? I mean, for God's sake, you have billions in your account. Is there a place in heaven where these monies are kept? And I ask myself, the life of a judge should be a life of sobriety. A situation where a senior advocate gives you a car worth 7 million, a senior advocate that appears before you, he now becomes an account officer, as it were. You allow him pay thousands of dollars into your account. I mean, for crying out loud, this is not a system where marketing of that kind is allowed. As a judge, your duty is to dispense justice.
Yeah, but my point is, if there was any substance to it, substance to these allegations, it's never been prosecuted.
But it explains the system we have in Nigeria.
Okay.
A system where they will tell you, bring the money,
Yes.
or we'll keep the money, go and say no more. That is where we are now. And unfortunately, one would have expected the EFCC, because
Yes.
I think it was because of the threats of prosecution.
Yes.
He had to resign eventually.
Okay.
His resignation or retirement is not far from that.
Okay.
But one thing is, what precedents are we leaving behind? It means that whenever any man up there as a judge stays,
Yes.
they are allowed to go. Once he has said to resign. Because the initial thing was resign. So meaning that if he had resigned earlier, nothing would have happened. He eventually resigned and nothing has happened. But the system at the end of the day has succeeded in doing one thing, which posterity would not be happy with. That when you still in Nigeria and you are ready to resign,
Yes.
you'll be allowed to go home. And you'll be giving all the full benefit of what you have ripped the system of. And the issue of voluntary retirement, the question has not been answered. All those benefits you would have gotten,
Yes.
would those benefits still come?
They were going to go. He's going to take because he resigned voluntarily. His resignation was accepted, so
there's
you
a
go
very
with
big-
severance
there's
package and all
this
that.
big question mark,
Yes.
which you're not getting signposts in our profession. And when we talk of the Nigerian judiciary, we cannot take away the issue of money, we cannot take away the issue of corruption
Okay.
and politics.
Okay. Let me two questions I will pose to you. First is, we're talking about the judiciary. Can you actually say the bar too is free from this? Because the current president of the Nigerian Bar Association has a corruption case in court, and is still the president of the Nigerian Bar Association. So, of course, he's presumed innocent until proven guilty. But in other crimes, such a prosecution would have been sufficient for certain decisions to be taken at the association level. But it's not been so. What if he's convicted? What happens? I mean, do you see this as being fallout of the concerns of people that the institution of justice in Nigeria is a monetized one?
I would say that it's quite unfortunate because when this issue of the NBA's president's anti-corruption case came up, I was one of the lawyers that came all out, because what I said in the media, that he should resign. As the NBA president, he will present us, I mean, in different fora, at the level of the NBC, most of the committees. So there's a tendency of you trying to influence the prosecution. And it's quite unfortunate because having been arraigned in the dock, do you still have the moral authority to lead the bar? Because we have a system that has been hijacked by the big names in the profession, the senior advocates and what have you. Otherwise, a country like Nigeria that is going through the throes of an anti-corruption war, the NBA president would have led that fight against corruption by stepping aside and allowing his trial. As Paul Usoro, not as the NBA chairman, the NBA president is not on trial. Paul Usoro that is on trial.
Look, it's not the presidency.
It's not the president.
It's not the office.
Because when we were doing those business or deals with the archive of state government, he didn't do that as NBA president. He did that as Paul Usoro and associates. So we are saying, and it's still not late to make this call to him. He should resign. He should not even step aside. Because when you look at the figures involved, money laundering, I mean,
more than a billion.
Very scandalous. And if he refuses to resign, and eventually his tenure ends, because in the first place, I don't think the NBA president has any form of immunity.
No immunity.
He has no form of immunity. No, it's very, it explains the kind of system Nigeria has. A system where individuals are bigger than institutions, unfortunately. And again, I will not go into his own election because that was the first MP election when deaf people voted.
So deaf people voted.
That is a different ballgame. It's a different ballgame. Gadzama contested his against Dawodu. For the period Dawodu was in office, that matter was then caught. The one adjournment to the other. So if the NBA, which ought to be a pace setter, cannot conduct simple elections. If the NBA has a leadership,
by the way, NBA means the Nigerian Bar Association.
If the Nigerian Bar Association, which ought to be an avant-garde, is seen to be involved in the kind of leadership crisis we have, of having a president who is in the dock or is still leading the bar. You cannot be in the dock facing prosecution and you are in the bar leading us as our president. And I can remember where some of this political engagement with government started. When Bayo Ojo, as our NBA president, resigned his office, we elected him to accept the office of Attorney General. The same office that the likes of Gani rejected on more than one occasion. We don't have the kind of leadership we once had. There was a time we had many of them Akabash.
Where is Bayo Ojo?
Of course, Bayo Ojo wanted to be governor of Kogi at some point. After he lost out, nobody heard about him again. It's quite unfortunate. There was a golden era in this country. I remember what the very first lawyer said.
So the chickens do come home to roost. They come home to roost.
I think we should pray that a day will not come where the dreads of society will say they want to be members of our profession. And we are gradually getting there.
I miss the heydays of Chief Gani Fawahimi, when we have moral authority to Gani Fawahimi once said he had never accepted government job, government contract, government patronage, nothing for government. And he was a wealthy man before he died. Anyway, corruption and Nigeria seem to be Siamese twins. You can hardly bifurcate them without endangering one or the other. And in this case, Nigeria will be the one endangered. Everywhere you go, from the airport, if you are coming into the country, you meet corruption. Immigration officers who are more interested in what you have to give, and all that. So you board a taxi and all that. So if we agree in our hospitals corruption is prevalent, in the court system from the bailiffs and all those people there's corruption, then the army, the police, don't talk about the police so that we will live here today. Okay, so if corruption is so endemic in Nigeria, and judges, magistrates and presiding officers of courts are selected from the Nigerian society, can we really, with all good conscience, expect them to be above board? Can we expect judges who are appointed, who grew up, with the corrupt system? They went to school, university, they saw the corruption. If you have to pass, if you have to do your clearance, then, while going, they practically trained. I think every Nigerian is trained in corruption from the beginning. The system itself, when the police stops you, you're driving your car, they stop you, your children are in the vehicle and they ask you for something, and you just give instead of having to go to court. So the children are watching. So there's this training, whether formal or informal, of everybody in Nigeria to be either corrupt or corruption minded or corruption aware. So can we pick angels as judges? Are we not going to pick the same corrupt people?
I think when you look at the Nigerian society, our value system,
yes.
Is it that the likes of Okuta, the likes of Kaldi Esho,
yes,
the likes of Obaseki GSC, Andrew Otutu Obaseki, the names are very many.
Yes.
The list is endless of justices of either the Court of Appeal or even High Court judges.
Yes.
Omo Adege who sentenced Danini.
Yes.
We have names, beautiful names. Unfortunately, his son, who is also a lawyer, went to grab names from thugs in the National Assembly. It is relevant in our value system. What happened? Where did we get it wrong? And I think the bulk of our problem was those years of military rulership, of dictatorship. that was when we got it all messed up. Where the youth can just come and grab power. You know, when you use that kind of jungle approach
Yes.
in governance,
Yes.
it has a lot of undermining the system. We had a situation in this country where people were not just going to be hanged
Yes.
by the hangman's noose,
Yes.
but they were shot. We don't have a proper
So,
system of value addition.
so by way of
Church has not even helped.
by way of a denouement, or by way of a conclusion, in a way, what will be your last words on this issue of monetization of justice in Nigeria?
I think my final word is we must revisit the issue of the process of the procedure by which judges are appointed.
Okay.
We should emphasize more on merits. For persons who were in practice and have maybe one or two cases against them,
Yes.
allegations against them,
Yes.
is it bad if we bring out the best from our profession as judges? I don't think the answer is no. The answer is yes. The process, like in places like America,
Yeah.
where but again, if you talk election,
Yes.
it's not the same problem.
It's the same
It's not
problem.
the same Nigerians that will come out to
Same,
vote.
yes.
You know, if you complain of, the electoral process is skewed to favor certain individuals, and this issue of money, so we need to first of all consider one thing. Certain constitutional provisions that has to do with our profession, namely composition of the NDC, there's need for that body as it is
To be enlarged or to be changed, the composition to
in terms
be-
of the appointing
to be
powers
changed.
of the Chief Justice of
Of
Nigeria.
Nigeria.
That should be reviewed.
Okay.
This issue of senior advocate should be revisited. It should be on merits. Because you find that some of these senior advocates will know what they do behind the scenes. I'm not going to say this is a classical example
Okay.
of how monies are paid and so some of these issues should be addressed.
Okay.
And I know too, as a lecturer, we have a bigger role to play because it is the lawyers who are responsible for raising lawyers that owe society that morality. This idea of blocking, this idea of sexual harassment, I mean, it's a big problem. Because when somebody goes through a system that allows for all of that,
Yes.
there's this tendency of, when I become a judge,
Yes.
when I become this, I'll get all
I'll get my own share.
So it's a vicious circle. So we need to rejig some of our systems, the process of appointing lecturers, appointment of judges, the law school. We should make it more professional.
More
We should spend
vocational.
less years in the university and more in law school, so that this issue of ethical, training, I mean, because very important.
Ethics.
Ethics and the punishments should be so stringent that when you know that as a lawyer you get yourself involved in bribery allegation, and there's a whole lot. The NBA must have a roundtable to address some of these issues, and I assure you the country will be better for that.
Thank you so much, my learned friend Andrew Enwata, barrister at law, and Stormy Petrel, for your very, shall I use the word, undiluted input today. I have thoroughly enjoyed you. I've had a blast. I hope that you viewers have also had a blast. Keep in touch with us. Let know your views and your comments about some of the issues we have discussed. Our social media handles are on the screen, our Facebook page, our Instagram page, our website, and perhaps you want to send a WhatsApp message so that it can help us to feel your pulse. And that's how it's been today on Law and You. Keep watching. I will keep bringing you the best. Thank you for coming.
Thank you so much for having us.
24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.